All right, welcome back. Our next presentation is public records, and this presentation provides an overview of the Louisiana Public Records Law, including the legal framework that defines public records, the rights of the public to access them, and the obligations of government bodies to provide them. Ms. Angela Heath is a senior attorney for the Office of the Louisiana Legislative Auditor. She began her career serving as a judicial law clerk for Justice Catherine Kitty Kimball on the Louisiana Supreme Court before going into private practice. In 2012, she served as a senior parish attorney for the parish of Jefferson before joining the LLA in February of 2016. In her capacity as senior attorney to the auditor's office, Ms. Heath researches and writes opinions on numerous and various questions facing the auditor's office, state and local officials, and public entities. She is a certified state agency ethics liaison and certified ethics trainer with the Louisiana Board of Ethics. She's also a certified fraud examiner and a member of the Association of Certified Fraud Examiners. She is admitted to practice in both Louisiana and North Carolina. Please welcome Ms. Angela Heath.
Hello everyone. I'm very happy to be here. Now, I am originally from New Orleans, so if I start talking too fast, you let me know, and I'll slow down. We're going to talk about the Public Records Law today, and if you have any questions, feel free to raise your hand and ask them of me. Now, the Public Records Law is enshrined in our Louisiana Constitution. Article 12, Section 3 says, "No person shall be denied the right to observe the deliberations of public bodies and examine public documents except in cases established by law." This is the foundation in our state for the Public Records Law and for the Open Meetings Law. This is about transparency of government. You're doing the public business, and so the public has a right to see what you're doing. They're called the Sunshine Laws because there's a famous quote by a justice on the U.S. Supreme Court that said, "Sunshine is the best disinfectant." It's when they were cleaning up bad government practices, all these backroom deals. People didn't know how their money's being spent, what their government is doing, right? So they're called the Sunshine Laws. Now, the Public Records Law starts at Revised Statute 44-1. And it's set, the very first line is that the provisions of the Public Records Law shall be interpreted liberally in favor of public review. This means courts are always going to try to look to give the public access to records if they can. And we're going to go over today the definitions, general requirements, some exceptions, retention, and responding to public records requests and violations. So first basic question, what is a public record? Here is the huge definition that's in the actual statutes. And if you want to read through that, you can. It's in your materials. What it basically boils down to is everything you use to run your entity in any format that you use it. If it's electronic, if it's paper, if it's maps, if it's blueprints, if it's pictures, assessors will have all kinds of aerial photographs, things like that. Everything that it takes to run your governmental entity is a public record. That's the baseline. Then, of course, there will be exceptions that come in, that things that don't have to be given up for some reason, usually of safety, security, or a right to privacy, and we'll go over that. When we're talking about the Public Records Law, it has a specific definition of what is a public body, of who this law applies to. And really, as you can see, it's a pretty thorough list that includes basically everybody, every kind of state agency, committees, subcommittees, any local political subdivision, state, parish, municipality, and quasi-publics that are designated to perform a governmental or propriety function, and housing authorities, affiliate housing authorities. So it basically applies to every governmental or public, quasi-public entity in the state. Every public records entity, every entity that's a public body has to have a custodian. That is by law. Can everybody hear me? I don't know if I'm too close to the mic or, okay. you have to have a custodian. That is the head of whatever your agency or entity is by law. But that person oftentimes will appoint someone else to be their designee. For example, in the legislative auditor's office, the legislative auditor is the designated custodian of all the records of his office. But he has designated his general counsel, Jennifer Shea, to be the one that people actually submit their public records requests. And us in legal, we handle the public records requests. Because that's the main duty of the custodian, is to maintain the records and to respond to public records requests. We recommend, now, like I just said, in our case, it's the general counsel who the auditor has designated. That might not be true in your entity. We recommend that you work with your attorney when responding to public records requests. This law is not really designed to make your lives easier, okay, or make your jobs easier. This law is designed to make sure the public can access all the records that they can without violating safety or privacy or, personal information. So it's basically everything that the public can get, they should get, and so the law can be a little complicated. There is a provision in the law that mandates that all public bodies have available on the internet the name of their custodian and how to submit to be able to submit this public records request. If you have a website, that's very easy. You put it on your website. Some places don't. There are organizations like the LMA that lists out people, like they'll list out every municipality's address, the officers, and that you could make sure it's on the LMA website, for example. The idea is that a person should be able to Google custodian for Bunkie, the village of Bunkie, and be able to have a name pop up, a contact name to pop up. Now, as I said, there are exceptions. Really what this is the record is public, but there's things about this record that the government has decided should not be available to the public for some reason. Now, the statutory exceptions start at 44.4, and there's a huge list in there. They include things like school building plans. That's considered a security risk to have anybody be able to walk in the street and get the building plans for a school. So they have made a special provision in 44.4, and they're listed, there's hundreds of them, that exempt those records from being disclosed. Other types of things that you might deal with, cybersecurity information or plans are exempted. Accident reports are exempted. Tax records are exempted. Health information of your employees are exempted. Certain personnel information, even though the personnel file, who works for you, what they make, is public, the legislature has decided that there's other information that should be private. They just did in 2024 a law. It used to be, if you remember, the home address and telephone number for a public employee, you had to opt out. You had to actually sign with your organization a paper and say, please don't publish my address and phone number. Now the legislature in 2024 said it's no longer opt-in, it's automatically exempt from disclosure in a public record. So the address, phone number, and personal email address of public employees by statute is exempt from disclosure. So the personnel record might have to be given up, but there's information inside it that you would redact out. That's because it's not subject to disclosure. But there's also some other things, attorney-client privilege, work product privilege. These are statutory privileges that exist. And there's also constitutional privileges, such as the right to privacy, that may access the public being able to get a certain record. That's why we say it's very important to work with an attorney, especially with the exceptions by statutory, because there's so many of them. Okay. Now, how long do you have to keep maintaining the public records? The first duty of the custodian. How long do you have to keep the records? People get very confused about this. You have to keep the records for as long as the law requires. Or if there is no law requiring you to keep it for a certain time, 3 years, unless you have a records retention schedule approved by the Secretary of State that provides a different time. So you can actually keep records for less than 3 years if you go through the trouble of doing the records retention schedule. I know a lot of people don't have a records retention schedule. You really should have a records retention schedule. And on the front end, it's a lot of work. I'm not going to lie to you, okay? But in the long run, it's very worth it for your organization to have this records retention schedule. Not only, it's required by law, okay? I'm acting like you have a choice. You're supposed to do it, okay? But it's very important to know what records you have and how long you have to keep them. Because different records need different retention requirements by law. If you got ARPA money, those records have to be kept for 7 years after the close of that fund, which is December 31st, 2024. So you need to know you need to keep these records for 7 years from that date. You also have things in employee files that had to be kept for different periods of time. Some things for 4 years, some things for 7 years, some things for even longer than that. So going through and knowing what you have and what you have to keep for this amount of time is very important. And then going through and looking at the things that don't actually have a date in law. To know, well, I'm going to keep these for the 3 years, or can I really keep these for 1 year or 2 years? This will help you cut down on all the paper and documents you have in your office. But also, the good thing is, if you have an approved records retention list, and the state archivist at the Secretary of State will help you go through that process to organize what you have and create that retention schedule. At the end of, so you've got a whole list of stuff that you're keeping for 10 years, okay? We keep like contracts 10 years after the end of the contract. We send a form to the Secretary of State and say, we're ready to destroy these records. She sends back a certificate and says, go ahead and destroy them. We destroy them. If somebody comes and asks for them, we can just show them, oh, sorry, here's my certificate from the Secretary of State giving me the permission to destroy it, and I did destroy it. You do actually have to destroy it. You can't keep it yourself. If you're keeping backup copies, that's defeating the purpose, because if you actually have the record, you have to give it up. If you're keeping backup copies because you have to be safe, you might need it down the line, revise your record retention schedule. Maybe you need to keep them for 15 years instead of 10 years. But it should be an end date where you can just, now some records are permanent. Auditor's reports, the actual issued audit reports are forever, right? Go ahead. I saw, okay, I answered your question. Yes. Hey, look, I did good, okay? Now, the manner of destruction for the records also depends on what's in them. If you have records that do have confidential information, stuff that would not be subject to public disclosure, like Social Security numbers, HIPAA information, health insurance information, that you can shred them, incinerate them, burn them, maceration, and pulverization. Those are the 4 ways. Records that don't have that information, you can use those 4 ways, but you can also just put them in the landfill or even recycle them, okay? So if you have not got yourself a records retention schedule, I do urge you to contact the archivist at the Secretary of State and get yourself a records retention schedule. Now, responding to public records requests, that's probably the things you, yes?
So, just to clarify what you said in the last slide, there's a difference between a requirement to destroy and being allowed to destroy when you schedule a product, right?
Right. You have to get permission from the Secretary. Once your schedule says it's time to destroy it, you do have to get permission and get that certificate back to show that you got authority to destroy the record. You're not really allowed to destroy a record until you get that from the Secretary of State. So if you don't have a retention schedule,
In your policy approved by the Secretary of State, like let's say your retention schedule is 10 years.
yes,
If you still have to have permission, even though that policy is blessed by the Secretary of State?
yes. Every time it's time to destroy, you send a list of the ones you're going to destroy, say these are now expired, to the Secretary of State. It's really the archivist office that handles this, and they send you back a certificate giving you permission, and that has to stay in your file. That'll be a permanent record.
Right, but a right to destroy versus a requirement to destroy, are you saying requirement to destroy?
Yes.
What if a specific department has a business need to longer than 10 years?
Then change your record retention schedule. Okay? And I'll have a good example. Somebody called us, and somebody had requested every email the mayor or the council, regardless of whether that person, like by the office, had sent in the last 20 years for this town, for this place. And they had it all, okay? Because they never deleted it. They didn't have if you don't have a records retention, you're not really allowed to destroy records. You have to get the permission to destroy them. Okay, and so the guy called me and said, do I have to respond to this? I said, if you have them, you got to give them up. He said, well, if we did have a records retention schedule, we wouldn't have had to keep them that long. Too late, after the fact, okay? So they had to respond to a huge record request, which was going to, take a lot of effort to do. But so if you do the work on the front end with getting yourself a records retention policy, following through when it's time, when they expire, to get your certificate back, yes, you can destroy those records. Then he could have just shown the certificate and said, oh, well, we only have it going back 5 years, right? So we can only give you for the last 5 years. Okay. Now, who can request a public record? In person, actually looking at the public record. Anybody 18 years old or over may come in to inspect the public record. The only exception is if they're a felon in prison, and that only applies to the actual guy who's in prison. His attorney can get the public records. Okay, there is one exception, different from that came out in 2024, that only a person who resides in the state of Louisiana and is over the age of 18 years old can get a record from the governor's office. That's a new law. It does not apply to you. There's no residency requirement for a public record. Someone can come in from Texas or Arkansas, wherever, and ask for a public record as long as they're over 18 years old. Now, anybody can get a copy, even somebody under 18, except for somebody in prison, of a public record. The idea here is that kids under 18 can't be trusted with actually seeing the original record, but they can get copies. If you as a custodian has the burden of proving that the public record is not open for copy or inspection, proving that somehow some exemption applies, whether the statutory exemption or the constitutional right to privacy or the like attorney-client privilege or something like that. Now, when a person comes in or emails you a request or however you're going to do it, press that. Okay. You're not allowed to ask them why they want this record. The only thing you can really ask them to do is give you their driver's license to verify their age and their identity. And you can require them to sign or register. You may have, and it's usually very easy, a form, and you want the request in writing. You can ask that. That's voluntary. They're not required in law to do it in a certain form. They can walk in and ask you for the record verbally. You can say, well, let me check that you're 18, and you can have them, and you're not even allowed to make a copy of the license. You can check that they're 18 or more, and you can have them sign or register. Those are the only things you can make them do, okay? Now, there was some controversy for a while because we're not allowed to ask anything, but sometimes they ask me for something I don't even know what they're talking for. I always thought that was common sense, that you could kind of clarify what they wanted, but the legislature put it in the law now. It specifically says in the law that you can inquire to say, well, I don't really know what you're asking for, and get some more information that way, but not why they want it. This is a more help me to help you so I can get you the right record that you want, okay? Now, if the record is so large and you have determined, the custodian, that it will substantially disrupt government to answer this request, you can deny the request under this special provision of the law that was just passed in 2024, 4432B2, but you have got to show that you have attempted to narrow the request. I would use this very sparingly because I don't know how the courts, it has never gone to court, so I don't know how the courts will respond. And they have a history in the Louisiana Supreme Court of really ruling in favor of disclosure. So this would have to be some really outrageous request. Maybe this law wasn't in place for the 20 years worth of emails. Maybe that guy could have used that one, all right? Now, it's very important when someone walks in to be calm, no matter how they act, they might be agitated, to show them a spirit of cooperation with it. That goes a long way with people. And assure them that you will get this to the proper person to respond to the request. Like, you can have some standard responses for common situations. You know, we're going to comply with the Louisiana Public Records Law. I'm going to get this today to the person who's going to be able to help you with this request. Some kind of things like that. Because I know sometimes you can get agitated. Yes, Barry?
So we have an online question.
Yes.
She says, if we have a retention schedule, do we still need a certificate to dispose of records?
Yes. Once those items that are there for, say, it's a 5-year period, you should be every year reviewing and seeing what's there. Okay, these records from this date back, from 2024 back, are now more than 5 years old, so we can destroy these. And then you send that list, it's a form, to the Secretary of State's office, to the archivist's office, and they send you back a certificate saying, yes, you can destroy them. And once you get that in hand, then you destroy them, okay? And you keep that certificate. All right. Now you can charge, okay. You can charge for public records. The law says can charge a reasonable fee for, now this is difference between in-person and a request by, say, email. You should have in your office, in your entity, protocols for both. Okay, so usually, if someone wants a copy though, they could come in person and ask for a copy. You can charge a reasonable fee. Now, they've kind of tweaked it. The state agencies have a law that is issued by the Division of Administration that they have to follow. Every other entity, local political subdivisions, you need to create a schedule of what your rates are going to charge for copies. And you can also charge for electronic copies. So if someone just wants them sent to them an email, that's very popular nowadays. In our office, we send a lot of emails with a PDF of the thing on it. We can charge for that if you want. But if you want to charge, you do have to have a schedule that you've adopted. Now, this is not, though, fees for in-person inspection. If they just want to come into your office and look at the record, you have to make them comfortable. You can't put them like in a room that's like 90 degrees in there, no chair, out in the shed or something like that. It's got to be, relatively comfortable, chair and a desk, and let them look at the record. And if they want to bring their phone in and take pictures, if they want to bring a handheld scanner in and copy them themselves, you have to let them do that, okay? Now, they can't bring a big old copy machine, okay? And the charge, by the way, going back to the schedule, you can't charge for the time it took you to gather the records. You charge for the copies, okay? This was a big problem. Assessors didn't like that rule because they spent a lot of money taking those aerial pictures and making maps, and people could come in their office. But that charge for that map is probably going to be higher than a charge for a copy, a copy of a piece of paper. But it can't really take in what it cost you to make the records. Now, this, by the way, the fees it's different for clerks of court. They have their own way of doing their fees. They have a specific statute for that. Okay. Now, how long do you have to respond to the request? Again, the difference between an in-person request and we have it where you can email us on our website. You want a public records request, they can just click it and they send an email in. Again, have processes for both. Maybe if they email it in, you print it out, you date the date of receipt, you put it in your registry, you get it to that person who's going to respond to the request. Have some processes to how to respond. But if they come in, they ask you for that record, and it's a public record, there's no doubt, there's nothing in there that you might have to redact, like they're coming in asking for the agenda for the last meeting. That's definitely a public record, definitely doesn't need to be redacted. The time to respond to them is immediately. You give it to them right then and there. Yes, sir. Did you have a question? Internal audit reports have a special provision in that 44.4 that once the report is issued, it is public, as well as any of the work papers of your internal auditor. There's an exception in the public records law that the legislative auditor's work papers, only the report is public. The actual work papers of the legislative auditor remain not subject to disclosure under the public records law forever. But the internal auditor's report is a public record as well as his work papers once the report is issued. Okay? All right. So again, if there's something that has to be segregated out, you can tell them that. If you're very open and honest with people when they come in, yes, these are public records, but there's a lot of, there's social security numbers, there's PPIs with personal identifiable information, things like that. And you're going to have to give me a day to redact it. Give them some reasonable time and show them that you're trying to get them the records that they want. They're usually reasonable. Yes?
Can there be a charge for the time it took to make actual copies?
No. Just a per page, just a charge for the copies.
On the date and time, is the custodian in charge of that, or do you have to pay it to the requester?
Wait, the date and time? What?
To fix the day and hour that they get to view the record?
Well, again, you have a time limit by law of when you have to get it to them. Work with them, though, and ask them, well, okay, can I have it to you on this day? It's within the time. Can you make it? If they can't, you should be a little flexible the next day, the day before, something like that, okay? We had a guy, yes. We had a request a couple years back, and it was right before Christmas. We have all the audit reports published now on the website. And actually, just because the Attorney General has said, so someone calls and asks for an audit report, we try to tell them, that's on our website. Would you like me to show you how to get that yourself? And they say, oh yeah, that's a great idea. And I help them to find it. And then I say, okay, so you want to withdraw your public records request. I make them say that to me just to make sure, because technically you're not supposed to say to somebody, well, that's on our website, you can get it yourself. No, if they want you to produce that copy, you have to produce that copy. But if you offer them a way that they can get it conveniently themselves, 99% of the time they'll take it. They just didn't know they could go to the website and get it. But you've got to do it in that way. And then at the end, ask them, so you want to withdraw the public records request, you're going to get it yourself from the website, right? And make them say yes. So one time this guy, but our records only go back to, I think, 1990. Okay, and we have audit reports for longer than that. They're all on microfilm. And this guy called, he wanted the state mineral board's audits going all the way back to when it was first created in law, which may have been in the early 80s, maybe 70s, I can't remember. And the process to take it from microfilm to put it into a PDF, I told him, you can come down, you can look at it on the machine. I don't think you want that. He said, no, I don't. I want to have the actual copies. I said, that's going to take, after I talked to the records management person that we have, that process takes some time to transfer it now from microfilm back to a PDF where we could give it to him on a flash drive. And it was right before Christmas, so people are on vacations and things like that. So I told him, this is going to take a little bit longer because it's like 15 years of audit reports. We've got to do that transfer process. I don't really think I can have it to after the new year. He was happy with that. He didn't need them right before Christmas, but I showed that we were willing to work with him and we were trying to get him his request. I saw a hand go up. Yes. Yeah. 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 Yes. Yes, listen, you have got to make sure you destroy the electronic copies as well. Because if you have it electronically, that's a very good point. You have to destroy it. You don't have to destroy a whole hard drive, but you've got to delete it off of your computers. They can wipe things off. You can't have even an electronic copy of these records. If you do, you have to give it up despite the fact that you destroyed the paper copy. You still have a copy of that record. So you have to make sure. Now, it's not destroying a whole hard drive to destroy it, but you've got to get it out of your system where people can access it. Okay. Well, if you transfer it, now you're getting into technical questions. If you're preserving it because you've transferred it to a new system, then yes, you can destroy the hard drive of the old system because you have it on the new system. But make sure you have the stuff on the new system. Yeah, that's a technology upgrade thing. That's not really, you're not destroying any records there. Yes, Barry.
So we have 3 questions.
Okay.
The first question is, if you have to get with IT to train your office on accessing employee emails, can we charge them for the cost of training, or is it still only per page?
You can't charge for anything other than the copy, a reasonable charge for the copy. That's a hard and fast rule. People have fought that for years. Now, the only other thing is when you have them come down, if they want to inspect it in person, and they insist it be after hours or on a weekend, you can charge them then for like the security and for someone to, you can tell them, well, this is going to cost you such and such to come in on a Saturday because we've got to pay somebody to be here. And okay, that is the only way you can do more than just a reasonable copy per page. Okay?
Are we able to perform the public records request after work hours and charge the requester if the request
No.
is large?
No, answer's no. There you go.
All right. And why did you have to convert it from microfiche to PDF? I thought you only had to give it in the format you had and do not have to create a record.
Well, it is the record. It's a different format. You don't have to give it only in the format that you have. Having him to come down, he wanted a copy of it. There's no way to copy the microfiche but to copy it onto a PDF, okay? That technology was much cheaper. So you don't have to create a record, okay? Now, it's not the format microfiche versus PDF. It is somebody wants a list of all these expenses and nothing else. Well, we don't keep a list of only that. We can give you these records, that information is in these records, but we don't have to create a new record to answer the request. So we weren't creating a new record. So that format is being used in a different way than what I'm talking about between microfiche to PDF, okay? All right.
Well,
Hope that answers everyone. Yes? That's okay. Yes. Those are technically public records, but there is a lot of things inside the personnel record that you do need to redact before you give it up. Yes, you do, but I would be very careful. Go with your attorney and redact all the, because even their insurance information that they've elected to take Blue Cross Blue Shield versus something else, that is considered personal health information, so that gets redacted. All that W-2 stuff, tax information is an exception. Like I said, there's a long list of exceptions, but a lot of things in there can be redacted and should be redacted before you give it up. Yes, ma'am. Or sir, sorry. No, once you've given it to somebody else's, once they've made the request, you've given them their copy, you don't have to track down every copy you ever gave everybody. It's just for you as the custodian. Okay. Yes. Well, there you go. How do you do that? I don't know. You can ask them. You're allowed to, but now there's a new opinion. I remember when we used to work at Jefferson Parish, I wasn't in charge of public records, but along with the public records request form that you could do by email, you were supposed to upload a copy of your driver's license. You were supposed to. I don't know what they're doing now, because now there's an AG opinion that says that you can't get a copy of the driver's license. So that's a little tricky to verify the age of that person in that way. Yes, Green. Yes. I'm telling you, you have 5 days within, excluding weekends and holiday, to get them the record when you know it's a public record, but you just don't happen to have a copy of it right now, or you need to do something like redaction. But people, when you tell them they're willing, you show them that you're responding to them, it doesn't have to be to the hour, okay? You can have some flexibility, make sure as long as you're getting them the record, okay? Now, Another thing we're talking about cooperating with people, if someone asks for a big records request, you can tell them, look, this is going to take a lot of time and effort. Be open, honest with them. We have to go through these. You've asked for thousands of dollars worth of stuff. The new law says that you can tell them what the costs are going to be and get prepayment. And if they don't pay, you don't have to start producing the records. If someone comes in, a certain person who always does public records requests and they didn't pay you for the last time they came in for their public records, you don't have to do their public records request until they pay their outstanding bill. Those are new laws here from 2024 that the legislature has put into place. So you can keep track of that. But there is an example I have heard of a town that had a record request that was voluminous. They were paid for it, and the clerk said, look, I'm going to get you as much as I can at the end of every week. I'm going to have to do it in batches because you can't stop your government from functioning to fulfill this public records request to make all these copies. But so the clerk made the copies as she could, and every week that person came and picked up that batch, and the next week came and picked up that batch. It took like months to get the whole records request filled, but she was obviously showing, I'm doing the best I can. I've got to redact all this information, and the person appreciated the fact that she was getting the records that she wanted. Yes, Barry.
What are the elements that make up the cost of providing these copies?
Listen, reasonable is the elements, okay? If you want to look at, reasonable is not defined, but I can always say a good guide if you don't know in your entity. If you look at the Division of Administrations, on the slide, it had the name of their uniform schedule. They charge 25 cents a page, okay? And they charge that for electronic copies. So if you send a PDF to somebody that's 5 pages, that's $1.25 you can charge for a PDF, okay? Now, if you adopt the same as the state, no court can tell you that's not reasonable because the state is doing it that way. Now, if you want to go and charge $5 a page, you will potentially open yourself up for a challenge in court. I don't know how the court's going to rule. I can't guarantee that. But $5 is a lot different from 25 cents. And if every other agency of the state is doing 25 cents per page, the court may indeed think $5 is not reasonable. But the standard is reasonable, and only the court's going to be able to tell you that when push comes to shove, okay? Now, average people, I don't know how likely you're going to get a lawsuit, but I'm going to tell you that a news media, they can fund lawyers to take you to court. All right, that's usually public records cases are some media companies involved, okay? Now, if for some reason you no longer have this record, you have to certify that in writing as well, that you no longer have this record, and tell the person when you think that, the last person who got custody and control. If you believe that the entire record, now I would say that if there's stuff that needs to be redacted, you should put that in writing, and the date, the reasonable date, you're going to be able to get it to him. Like that guy with the reports, I told him, look, we're 2 weeks before Christmas. I can get it to you first week of January. He was fine with that. That was like a 3-week delay. That was not within the 5 days. But we had talked, I had put it in writing to him, so we were all clear on when he was going to get the records. If you think, for some reason, that this record you can't give up, this is definitely something that's excluded. You don't have to give it up in the public records law or right to privacy or any of those other concerns, exceptions we talked about apply. That letter must be in writing to the person within 5 days and explaining what the objection, why you do not, this is not considered something that has to be disclosed. I highly recommend you get your attorney to help you draft that letter in those cases. Because what can happen if you deny the public records request? If they're denied, they can basically file a civil suit against you in the parish where the custodian is located, and they can get an injunction, declaratory relief, or writ of mandamus. They can get attorney's fees, costs, and damages as provided by laws. So that's why no matter what, answer the person within 5 days. Make sure they get some kind of answer, okay? Even if it's the answer is, oh, yes, we're going to get them to you, but we need more time, and this is why, or no, you're not getting the record. You definitely make sure you answer, because if 5 days just passes with no answer, they can go to court for you, against you. And if you deny them, they can challenge that denial. And it's actual damage is civil penalties, but now in 2024, the legislature, it used to be that the custodian had personal liability as well. The legislature has changed that. It is now that only the entity has to pay those fines. The custodian is no longer personally liable. Two kind of interesting cases here. I'm going to go through them real fast. Shane versus Jefferson Parish. This was a case involving internal auditor. JEDCO had an executive. JEDCO is the Economic Development Corporation component union of Jefferson Parish. JEDCO's director got fired basically because he was using work time to send personal emails involving political activity with other people in the parish, kind of high players in the parish. And there was rumors about, they sent the internal auditor in, the internal auditor did the audit. Yes, that was the case. And so the guy got fired. And so the Times-Picayune wanted copies of those emails because, they had stuff in those emails like, yeah, that guy's a real jerk, but they weren't saying jerk, so it was kind of embarrassing type of emails. JEDCO said, hey, these are personal emails. They aren't work related to JEDCO, so they're not public records. That's one that's not, if you have personal stuff, that's not subject to public records disclosure. So Times-Picayune, being smart because they have smart attorneys, said, well, the internal auditors for Jefferson Parish, his work papers are public once the audit is issued. He must have a copy of those emails in his work papers. So they went to Jefferson Parish and they asked for those emails. And Jefferson Parish said, you know what, you're right, these are public records, but there is a right to privacy because the people he was communicating with were not public employees. He was, different people, big donors in the parish. So what we're going to do is we're going to give you the records on this date, but we're going to notify everybody that's on those emails, and if they want to bring a claim of right to privacy, they can. Henry Shane, who's this developer out in Jefferson Parish, brought the case saying, don't disclose them, it's a violation of my right to privacy. Long story short, it eventually goes to the Louisiana Supreme Court, and the Supreme Court says, yeah, he's got a right to privacy, but Jefferson Parish can just redact the names of everybody who's not a public figure or a public employee and email addresses of everybody who's not a public figure or public employee. And JEDCO, by the way, intervened in the case and said, no, Jefferson Parish is not the custodian. These are our records. They were made on our computers. And the court said, and this is the important part, the court said, a public record can have more than one custodian. Yes, JEDCO is the original custodian, but once Jefferson Parish, through their internal auditor, took it for a real government purpose, an internal audit, Jefferson Parish became custodians of the copies. Jefferson Parish had copies, not the originals like JEDCO had. But the public records law says originals, copies can be public records. So that just shows that how the court will really bend over backwards to go for public disclosure. Yes.
4 questions.
Okay.
I think they're going to be quick answers, hopefully.
Okay.
Can a request be made over the phone verbally?
Yes.
Okay.
Yes, people do that all the time for us. We keep a record of the name, who called, so how we can get back in touch with them, but yes.
Okay.
Yeah.
Somebody wanted you to repeat the part about if they owe an outstanding invoice and you don't have to fulfill the new request?
Yes, until they pay it. If they have already, you did a public records request form before, it was $100, they never paid it, then when they come back for a new public record, you can tell them, you got to pay this invoice first. The law lets me make sure you settle your bill before I do it again for you.
Is the custodian subject to legal action personally?
Well, not anymore. That's the change in the law in 2024. They changed the law. They might be named in the lawsuit, but the actual personal liability no longer applies. It's the entity that's going to be liable for those costs.
Okay. And the last one is an out of office message considered a response and
No.
responded in a reasonable time frame?
If the person who usually answers the records is going on vacation, you need to have a backup person to handle the public records requests. That's your office, okay? Bulldog Society, New Orleans Bulldog Society, the city of New Orleans contracted with the SPCA, the Louisiana SPCA, to basically run their shelter, okay? And they had the authority. They used City of New Orleans trucks with the City of New Orleans emblem on them, and they were able to go out and actually write code violations, like if you have too many animals or whatever. They could go out. They picked up the strays, they picked up the dead animals, they ran the shelter, but they also gave code violations. Anyway, the head of the shelter in New Orleans said, we have adopted out all adoptable dogs. Some dogs are like not adoptable, I guess. And the New Orleans Bulldog Society, I don't know, I'm not an expert on this. So the New Orleans Bulldog Society, which is a local rescue, it's one of those home rescue type places where people connect with other people and they take the dogs in their own homes and foster them and try to find owners. Well, they said, well, I want to know about that because you had this bull mastiff and that dog is no longer there. So what do you consider, they asked all kinds of records. What do you consider an adoptable dog? What are the records of this specific dog, et cetera, et cetera. SPCA said, we're a private nonprofit. Public records law does not apply to us. And so the New Orleans Bulldog Society went to the City of New Orleans. City of New Orleans gave them the contract they had with SPCA, said everything else, that's SPCA's records, not our records. And so New Orleans Bulldog Society sued on the theory that the SPCA was acting as an instrumentality of the government for the City of New Orleans and therefore should have to give up their records. They should be subject to the public records law. SPCA said, look, we have this contract with the City of New Orleans is like $2 million. That's a drop in the bucket. We are a $50 million a year. I'm making up these numbers, but the contract was $2 million. But we have all these money from private donors that we shouldn't have to open up our books to everybody. Long story short, the Louisiana Supreme Court said, yes, you are acting for this contract with the City of New Orleans as an instrumentality. You're cloaked in the authority of the City of New Orleans. You're handing out code violations. You're going in City of New Orleans trucks. And you're actually doing something that's a governmental purpose. It's the purpose of the City of New Orleans. One of their public health, safety, and welfare is animal control, is included in that. And they have basically given it to you under this contract. Yes, your books for your private donations do not have to be given up, but every record in connection with this contract, which has to do with running that shelter, which has to do with euthanizing certain dogs or not, is subject to the public records law. So if you are contracting with private entities to do governmental services, those entities, for the purposes of that contract and that money, and they actually said $2 million might not be a lot for you, SPCA, but that's a lot of the taxpayer money that's going towards that contract. So it's not inconsequential as the SPCA was trying to claim. So if you contract with a private entity, if they're taking over really a governmental function, their records in relation to fulfilling that contract will be subject to the public records law in the state of Louisiana. Okay, any questions? I think I summarized this. Any questions? Any more? Yes. Yes, you have to be very careful of that. I advise, social media posts are public records. If you have a Facebook page, it might be a very good idea to close your comments because sometimes people can put really crazy comments in there and you're going to have to preserve those as a public record. So maybe you just want to be able to communicate with the public, but not just let anybody comment underneath you, because who knows what some crazy person will say. And you have to be very careful yourself if you're using your phone to do public business on. Just some people just have a work phone and their own phone. Now everybody just only has usually their own phone. If you're texting with people at work about work, you really should be preserving those texts, coming into your office, uploading those texts into a file and preserving those because they can be subject to a public records request as well. Yes. Oh, I'm sorry, did you have a follow-up?
Yeah, Facebook is especially problematic. We ran into that because we had our Facebook page. Facebook page has to be under a social page.
Right.
It won't allow it otherwise.
Yeah.
We put it under the mayor who was voted out.
Okay.
We wanted it taken down.
Right. You see, so you have to work through how you're going to handle that. You can work with the IT people. I'm not a tech person. Yeah, work with Facebook and make sure you get yourself a governmental page. Yes.
If a records request is made and paid, however, the individual does not come back and pick up the documentation, how long are you required to hold on to the files before disposing of them?
Honestly, use your best judgment. I would hold on for a while. I would keep the records of every time I tried to call to contact them. I mean, I would give them a good amount of time but that would be a personal, use your common sense, best judgment. I wouldn't be right away. A couple of months at least, maybe even a whole year. But there's no requirement in law for that. Use your best judgment. Anything else? Yes, I'm sorry. I didn't. Everyone's turned this side.
So if someone, you can't charge if somebody wants to come look at them.
Right.
If you have to do those redactions and make copies in order to do the redactions.
You can't charge for that.
Okay. So no
Because
matter
they're not walking out with the copy.
Okay.
You can't charge them for it. Yes. Anything else? Yes. Yeah, it applies to every governmental entity in the state of Louisiana. State agencies as well. All state agencies have to do that. It applies to every governmental agency. So get your records retention schedule right. You done? All right. It was a pleasure being here. This is our website. Oops. This is our website. You can go on it's lla.la.gov. Our stuff is under go to resources on the top of the page. Hover over it, hit legal assistance, and you'll get our legal FAQs. Everything I told you today, there's a whole FAQ, question and answer format on the public record law, as well as all the other public laws like public bid, open meetings, etc. We have little videos on things called legal minutes and frequently asked questions, okay? So you can get a lot of information there. And here is the contact for me. That's the number back to legal. You can call and talk to me, to Jennifer Shea, our general counsel, or Patrick Vergadamo, the other attorney there, okay? With anything you need. Thank you so much.
Thank you, Angela.